Suppose that a defendant, a prisoner, claims that there was a fatal error at trial, but doesn't bring a 22 after the direct appeal does not bring a 2255 for 3 years, therefore misses the statute of limitations. What would be extraordinary about that situation, and would allow the prisoner then to try to get a lot of the relief that could have been obtained, maybe all of the relief that could have been obtained under 2255 by filing a 3582 motion?
Well, Your Honor, certainly there can be some things that are extraordinary and compelling about those circumstances. One, we would have to understand what is the prejudice that fatal error had on the verdict. Did it change it from an acquittal to a guilty verdict? Then, why did the defendant, if this was such a glaring error, why did the defendant not bring a 2255? Maybe he had a mental breakdown and couldn't speak to his lawyers during that time. We don't know the circumstances. All we're saying is that all of the circumstances should be considered as part of the extraordinary and compelling analysis, the same way that personal circumstances.
I understand that. To go back to your answer to the Chief Justice's question, suppose you're advising a whole string of prisoners who have been convicted, they've lost on direct appeal, and for one reason or another, they all have claims of trial error or some other flaw in their conviction, but they're all barred from proceeding under 2255 because of the statute of limitations or some other factor. And you look at their claims and you think this is not a ridiculous claim. Would there be any circumstances in which you would not file a motion for sentence reduction?
Well, Your Honor, I think the same could be asked of anyone who has any medical illness or is approaching older age. Is there any reason they wouldn't? And this is precisely what the Sentencing Commission is authorized to do, is to put in guardrails. But to Your Honor's question, I think the close calls of when there's, potential error, I'm not sure that that's the sort of unfairness that courts would typically find extraordinary.
Well, I'm not even talking exclusively about close calls. I'm talking about arguments that are not so frivolous as to damage your professional reputation if you brought them.
Well,
wouldn't you always do that?
Absolutely, Your Honor. And
so if this isn't going to be unusual,
I think
it's going to be standard.
I think what would be unusual is that courts would find the compelling circumstances that we're talking about. The First Circuit I cited in our reply brief, after Trenkler in 2022, there has not been a single case that we found where a court has granted a compassionate release motion in a situation where an argument that could have been raised on habeas was the basis for that motion. So we haven't seen that level of motions being filed, but we certainly anticipate, and Congress anticipated, that the Sentencing Commission can put the guardrails. The same way that the Sentencing Commission, I'm sorry.
Keep going, sorry.
I'm just going to say the same way the Sentencing Commission dealt with the flood of these compassionate release motions during COVID.